Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Wow, what a hearing we had today. Another very volatile hearing between the defense, sometimes the Alan Jackson and Judge Cannoni. Start out showing you that. But it was all about the Karen Reed's motion to dismiss, where she does what all innocence fraud campaigns do, which is if you have a ton of evidence against you, you get into the minutia, you expand some tiny piece of very unimportant, piece of the case, and expand it and make it everything and make it emblematic of a larger conspiracy, corruption, because essentially all innocence fraud campaigns are really very much like conspiracy theories, propaganda, repeated, and you repeat it over and over again. You talk about it connected to some vague corruption. So you take a tiny acorn of truth and you grow a great oak, a great fraudulent oak out of it. And that's what they're attempting to do. We saw in the beginning of the case with Lieutenant Fanning, who is the commander of the security operations at the courthouse. Somehow he's now involved in jury tampering and I'm just going to look at that first. Judge Cannoni. So here's Alan Jackson going on and on about how this Lieutenant Fanning poisoned the jury pool. And I believe this is connected. I have to listen again, so forgive me. But I believe this is connected again, and I have to read the motion to dismiss again. Connected to a juror who was thrown off it, who they thought was a defense-friendly juror. Turns out we heard about this juror. She was a turtle rider who bragged at a bar about getting on the jury, fooling them, lying in voir dire, and she got thrown off. They're saying that my Lieutenant Fanning had something to do with this. And of course, he wants to protect his own. And here's the fireworks between, this is what Court TV calls it, between Alan Jackson and Judge Cannoni, who says, you have to know that it's the court officer that deals with the jury. And having recently been a juror myself, I was talking during the live stream about it. You have one officer, at least in my case, assigned to you, and they're like your camp counselor. You don't go into court without them. They They walk you out, for breaks during deliberations. I mean, they're really your liaison to anything that you might need. You don't really you really don't really have any direct contact with anyone else. But here is Judge Cannoni and Alan Jackson going back and forth on this, meaning you lied to the court again in your motions. You had to know this. And if you don't, David Yannetti knows that the court officer is the only person that deals with the jury. Take a listen.
That Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute. Okay. Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now...
What? That's not reasonable. Because he has a big title, commander of security operations, you're going to think that he's in charge of the jurors? You've been a lawyer for how long, Alan Jackson? This is just sheer nonsense. Sheer nonsense. Sheer lying to the court again. And then they accused Hank Brennan of lying to the court and asking Judge Cannoni to hold Hank Brennan to the same standards as Alan Jackson and co. As if lying about to the jury, to the court, to the public for months on months and months on end in your filings, on TV, in your questioning. Hold on, I may have a kitty emergency. Hold on one second. All right, averted. Kitty emergency averted. As if that's the same thing. As if lying for months and months and months and about your most important witnesses is the same as misspeaking and correcting yourself.
Telling me he wasn't. Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander.
You were told that at sidebar. No, we weren't. Well, I have the transcripts. You're caught dead to rights. Oh, yes. Well, we were told that, but we were just told what his title was. So just shift the goalpost. This is exactly how innocence fraud works and how liars operate. I mean, but I would love to say that Judge Cannoni is going to put her foot down, but it doesn't look like it's going that way. Or if it is, she's not showing her hand at all. I would think that if she thought it was a serious enough violation to do any of the things that I think are really necessary, that she wouldn't be inviting them back into her courtroom for all these hearings. I think they should be thrown off the case and brought up for disbarment. That's how I feel. They were their best witnesses, these ARCA witnesses. Most important witnesses in the case, most convincing witnesses. And they lied months on end, not paid. The Commonwealth could have used them too, but didn't because it wasn't helpful to their case, meaning the Commonwealth turned a blind eye on some factual scientific information. What a lie.
Of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good.
Right. With all their private investigators. Well, they have time. Karen Reed has endless time to go on people's Facebook accounts and investigate them, pull up pictures, embarrass them, start federal investigations. But no one can call up even the calendar clerk's got to know and say, what does this guy do? What is that? Or even call up Lieutenant Fanning himself and say, what does your job entail? Find a handbook? I don't know. They can't do that.
Faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning. The
I
court
think it was
declined.
Miss Little.
I'm sorry?
I think it was Miss Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of.
He did not say he was looking for nudes. Someone asked him, did you find any nudes? And he said, not yet. So it's like if I were, I don't know, looking out the window, talking to someone on the phone. Did you see any joggers go by? No, not yet. Well, Roberta was on the phone looking for joggers. Just happened to be looking out the window. His job happened to be going through her phone. How did this looking for nudes thing? And Alan Jackson hardly is one to talk. Mr. Elbow on the knee of Karen Reed at Smith and Walensky's bar, having drinks. Mr. Alan Jackson with his arms wrapped around Karen Reed from behind. They seem awfully cozy. Married man. Hardly one to clutch pearls.
Of the extensive security operations attendant to this case and
never mind Mr. Alan Jackson of the frequent lying to the court and to the jury. You're in no moral authority, Alan Jackson. You never were, in my opinion. saying on the live stream today, you know, everything I said about these lawyers, I got a lot of flack for. Oh, you're not fair. You're biased. You're a cheerleader for the prosecution. They're just doing a job and they're doing it well. You just don't agree with them. They're hardly fraudsters. I've been studying innocence fraud for over a decade now. I know how they operate. This is unusual because it's all pre-trial, but this isn't anything new for me. These are lying, totally without conscience lawyers. And they seem to just get pleasure. The more they bamboozle the court and the public, the more they love it.
He's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion
was to not check it out and throw it in our filing. They knew he had nothing to do with it. They just have to make it look. They have to somehow connect it to Proctor and make it look like something nefarious was going on with the jury. When frankly, it makes me think that there's more, that they may have done jury tampering themselves in ways that we haven't found out about yet. Always point the finger first, very much like a Scientology style campaign, attack, 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 never defend. And when they know they're doing something, just point the finger at the Commonwealth. There is corruption in this case, but it comes from the judge allowing it, and it comes from the defense. And it comes from our complicit media not calling it out. No matter how blatant the fraud is that goes on in court, they'll never call it out. But if an officer writes some inappropriate, mean text that I would expect be written about me, if I killed a police officer the same way that Karen Reed did, I'd expect the officer to have some choice things about my ailments, maybe my asthma, my heavy breathing, and my asthmatic breathing, and my New York accent. And I would expect to be called to see you next Tuesday and a B and a whack job and whatever else. And Karen Reed herself said she wasn't offended by it. So what are we talking about here? It's like the crime of possibly hurting Karen Reed's feelings is akin to the crime of, actually worse than the crime of clipping your ex-police officer boyfriend with your car and leaving him to die in a nor'easter. Freeze to death. Succumbing to his wounds and freezing to death. I mean, what an awful, awful, awful crime this is.
Conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago, when you already knew that he did not have any access to the jurors?
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed it.
Oh, they want an affidavit so that if he's ever maybe passed by a jury, they can say that he perjured himself in his affidavit. That's what they want. They want an affidavit from Lieutenant Fanning saying, I don't have anything to do with these jurors. And then maybe one juror walked up to him and it's like, where's the water fountain? They take a picture or a video. Oh, see, there he is directing a juror to the water fountain. He has, interaction with them. It's like, they couldn't check this out. This is like a Lessie level of argument here. Total nonsense. Hey, kitties. 1993. Thanks for the super chat. AJ talks to the judge like a petulant child. I agree that this judge is part of this fraud. If she wasn't, this case would have been over last year. Agreed. And I'm not convinced with how brilliant, Hank Brennan is certainly a very brilliant lawyer, but if they get turtle riders on the jury, we're headed for another hung jury. Just not convinced. I'm also not convinced in Turtle Boy's case. It looks like that may be dismissed. He got another charge last night. He was in court today. So he has 20 witness intimidation charges against him, and Judge Canoni welcomed him in her courtroom. I mean, how many bad decisions has this judge made? She just won't put the brakes on any of this, and they know that. So every time it's just gotten more flagrant and more flagrant as they go on. They weren't allowed to develop a third, they weren't allowed to mention a third party. They were only to develop it, but there it is in the opening statement by Yannetti.
The opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is there evidence
you know it's not true?
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect?
Yes, indirect. What's indirect? What is indirect? How do you describe indirect?
Correct with any of the jurors. I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
Clearly you don't. Because she just asked you to accept it as true and you wouldn't. So when she said, now that you know it's true, he says, no, I don't know it's true. And then you see how they talk out of both sides of their mouth, these lawyers? So now that you know it is true, what are you going to do about it? And he's like, well, if it is true, she's just trying to move this along. But there's never any consequences for acting out, and for lying to the court, and for committing a fraud on the court. So it's going to happen again and again. They're just going to get more. I mean, it's just going to become. I'm scared for this trial, frankly. Aren't you guys? Let's see what her decision is. But fact that we haven't seen any sanctions. And spare me if she comes down with some kind of monetary sanctions. That will be dealt with some more raffles. I mean, has she heard about any of these raffles? Have they gotten in any trouble for that? No. Invites Turtle Boy, moves the court to a small courtroom ridiculously, where we all have to suffer. Including the witnesses, and especially Lally, where it's not mic'd correctly. I mean, she has accepted more nonsense. Allowed Marie Russell in, allowed Richard Green in. Left out barred any of Karen Reed's conflicting statements from the first trial. For what reason, I don't understand. From the jury ever hearing Karen Reed's interviews, never really putting any gag order on Karen Reed or her lawyers. She's been like a silent patron of this innocence fraud campaign. And in court, not so silent. And is it because Yannetti seems to have a very big name in this area? She impressed? Or is it because, I tend to think it's because she's a former defense attorney and used these kind of tactics herself. Gets a kick out of it. I don't know.
We will move on from that, Mr. Jackson. We'll move on from that. So,
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution.
How did they know that this juror was so defense-friendly? Did they have anything to do with getting this juror on the jury? Did someone tip them off, like Turtle Boy, to pick her? That's where I'm at right now. How would they know otherwise? That she was so defense friendly.
Of my client, that's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired.
Okay, I've had enough. You get an idea of those are the fireworks, as Court TV described it. Curious just about Turtle Boy. Let me just pull up my bookmarks. And forgive me, I just, this is going to be a kind of a looser show today than usual. When the hearings go so late, I just don't have as much time to prepare. But I wanted to show you. Let me make sure. Hold on one second. Let me pull up the right one. some curious things. So they also went off about the inverted. I'll get to all of it. Okay, 1 second. Here we go. So here's Jams talking about, so they talked a lot about the inverted video. Here's Jams saying, well, almost a month before, this is something that Hank Brennan argued today in court, that the Sallyport video was just set on being mirrored. I call it mirrored, a mirrored look or an inverted look. That's the way the camera was set. And here it is, a month before Karen hit John, the Sallyport camera was recording inverted footage. Imagine that. They also talked about grainy footage, missing footage, very much like they had listened to a lot of the Epstein coverage, that coincidentally the cameras were just turned off at the right moment, at an opportune moment. So they weren't given the outside of the Sallyport video. They only heard about it in testimony, and Hank Brennan had to say it was wrong of Proctor to not hand it over. But here it is, but I'm sure it's wholly inconsequential. I'll show you why in a second. They also talked about the pieces of the taillight being described by one officer witness as cracked. So, the proper description is smashed to smithereens, in my opinion, but he used cracks, so they jumped all over it. And he said it was just cracked then, and they found 47 pieces. How does a cracked taillight have 47 pieces? But you will hear what he says. Also, Karen Reed's behavior here. Karen admitted, so Hank Brennan today plays in court that Karen Reed read in court that some statements by Karen Reed where she admitted to Gretchen Voss that her taillight was broken and missing that morning before Jen McCabe and Kerry Roberts went back to 34 Fairview Road and said you could even see the bulb. And here's the clip that Hank Brennan played in court.
She said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been you. She said.
So what he's saying is it's not exculpatory. The Sallyport video that is held, they're calling a Brady violation, meaning they didn't hand over something that could be exculpatory to the defense, was not exculpatory. And Julie Carpenter on X says, and now we know why Karen Reed came flying down the steps after November, yelling at the press, because they were fighting to get Gretchen Voss's unredacted, unedited interviews with Karen Reed. And they were saying there were admissions in there. And Karen Reed says, well, if you didn't report on these admissions, then you're all part of a cover-up of my crime, essentially. This is not her words, they're mine. But that's what the press does, is because it's a much more exciting story. Karen Reed, the wrongfully accused woman up against the system, than Karen Reed, the guilty cop killer starting an innocence fraud campaign. Or Karen Reed or even putting in a little bit of the truth. Karen Reed might be a killer, or she might be an innocent woman. Either way, the public loves that story. And the press will exploit that. And the big awards, like the Peabody Award that Sarah Koenig got for Serial, all come from the wrongfully accused, wrongfully convicted side of the big bucks. Not too much money in the rightfully convicted police, government, got it right story.
Yes.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
That's a fishing expedition. That's exactly what the defense has done, what Karen Reed herself has done since the beginning, gone on a fishing expedition, looking into people's Facebooks for connections and exploiting them. This is from Lady Justice. This is a good catch that she got. The Commonwealth moves to amend. Alternatively, the Commonwealth moves for a partial unsealing of the June 20th, 2023 transcripts to allow the Commonwealth to reference statements made by defendant about the damage of her taillight in order to effectively rebut the defense's allegations. So they made a special motion just so they could use those statements in court today. And I'll get to this later. Get to that later. Here's where this is concerning to me. If this is a true report from court today, the judge said in Aidan Carney's hearing to dismiss the case against him for the now 20 charges of witness harassment and intimidation against him, the judge interrupted the prosecutor Cosgrove and said that Aidan Carney is a satirist and his work is satire. Now, why I've always been skeptical that we would see a conviction with Aidan Carney. But now, if this is true, more so than ever, because satire is protected speech. And you could call his rolling rallies, his events of basically her going to the businesses of the witnesses as satire, part of his satire. And if that's true, then it's going to be dismissed. If he sees it that way, I can't see how this is going to move on. But it's rolling at a snail's pace. They have no trial date. So, wanted to get into, oh, thanks, Tammie. How come AJ got to stay on? Because, well, we don't know. We haven't seen anything in writing. We don't have a hearing till the 18th of March. And Judge Canoni hasn't ruled on the motion for sanctions. So we'll see which way she goes. I would be surprised if she does anything. Looks like she's going to reject them, because I think that she is a former defense attorney and she used all these techniques in her time, and she's very permissive. She's allowed fraud after fraud to go on in her court, in my opinion. But I thought he was done for me too. I thought something might happen to him. I thought any other judge was. And, when I was in federal court at the Nexium hearings, Judge Garifas in that case threw out a reporter for giving a look from the gallery. Meanwhile, Karen Reed is allowed to roll her eyes. And we have ruling after ruling that is just bizarre. And in the case, especially of Richard Green, I don't think it follows the law. That's my view, but I'm not a lawyer. And I think other lawyers would agree. Certainly Hank Brennan would. It was great to see Hank Brennan reference my opening. Okay, does everybody remember my opening today? I don't know. Have you seen it too much? I think I'm just going to show you a little bit of it. But he referenced how the defense has a moving defense, meaning it's like a moving target. You can't nail it down. So he says in one interview, Karen Reed stood on the court steps and said, "I know who did it." In another interview with her lawyers beside her, they said, "We don't know." So I thought, is Hank Brennan watching my show? I know he's not, but it made me laugh. So he
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for the killing of John.
Okay. So that was fun to see. And so I just want to, actually, you know what? I'm going to take a quick break and make sure it's queued up just perfectly. I will be back in 1 minute. Don't go anywhere.
A glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, so here we go. Queued up. So this is Hank Brennan's just finishing up talking about how Proctor should have handed over the outside video of the Sally Port in addition to the inside. So the video of the outside of the Sally Port, but didn't, but it's not exculpatory, okay? And here's why. Let's take a listen.
The import of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros' testimony. And if you
Is that me? Is that my computer doing that? Is that my computer doing that? Holy cow. Hold on. Let me make sure. I don't know if my internet's going out or it's just being funky. It's on. All right. Hold on 1 second. Let me see if I can fix this.
Is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros' testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked. But they forgot the next part. And there was a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, that taillight is...
Wait, hold on one second. So I wanted to show you exactly what he said, Mr. Barros, and here we go.
But you did include in your report that while Proctor and Buchanan were on scene, they retrieved the cell phone of John O'Keefe, correct?
At some point during the day, they did. I don't know where from. So there's multiple.
Yeah, I'm asking about your report, Trooper. You know I'm questioning you about your report.
No, I understand. I'm explaining.
No,
I don't know what scene it's from.
Explain, sir, most respectfully, until Mr. Lally questions you.
Objection, Your
Okay,
Honor.
so no comments. I think to speed things along, do you have your report with you?
I do, Your Honor.
I think it'll make it easier,
Oh,
Ms.
can you read the
Giannetti.
first two lines of that?
Let him grab it.
Go.
Can you read the first two lines to the jury, please?
Yep. On Saturday, January 29th, 2022, Trooper Michael Proctor and Sergeant Jeri Buchanan of the Norfolk District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Through his investigation, was found O'Keefe was a victim of a motor vehicle homicide. While on scene, Trooper Proctor secured O'Keefe's phone and brought it to the Norfolk DA's office for forensic analysis.
Okay. So you'd agree with me that you included that clause, while on scene, they secured his phone, did you not?
I did write that.
Okay. And that was back on February 4th of 2022, correct?
Yes, it was.
Within 6 days.
These troopers hate writing these reports. So if they retrieved his phone at the hospital or somewhere else, then it's not on scene and there's an error. They went crazy all through the trial with these tiny errors in these reports.
Of John O'Keefe being found mortally wounded on Albert's lawn, correct?
Yes, sir.
And at that time, you knew that the crime scene...
Mortally wounded. I mean, everyone there seemed to know he was gone, expired, dead.
Was 34 Fairview Road, correct?
No.
Yet you put in your report while on scene, did you not?
Yes, I don't know what scene they recovered from. I know they went multiple places on the 29th. They didn't get back to me till 7:30 that night almost, when I first got the phone.
Well, you'd agree with me that the Canton Police Department wasn't the crime scene, correct?
I never said crime scene in my report. I wrote scene.
Okay. Well, Canton Police Department was not the scene of any crime.
Do you see how they capitalize on words? These lawyers are wordsmiths. So he's saying, is it the crime scene or is it the scene, right? And then he capitalizes. Whoop, oh, I stopped sharing when I didn't mean to. Hold on one second. He goes on to say that his cracked taillight means that it was largely intact. If you don't say what it really was, which was smashed to smithereens. I hope this is the clip I'm looking
Yes,
for.
I don't know what scene they recovered from. I know they went multiple places on the 29th. They didn't get back to me till 7:30 that night almost, when I first got the phone.
Well, you'd agree with me that the Canton Police Department wasn't the crime scene, correct?
I never said crime scene in my report. I wrote scene.
Okay. Well, Canton Police Department was not the scene of any crime, was it?
I don't know. I don't believe so.
You don't know if the Canton Police Department was the scene of a crime.
I don't think it was.
You don't think it was? Okay. Correct?
Yes, sir.
And at that time, you knew that the crime scene was 34
Okay.
Fairview Road, correct?
And then they go further to talk about the cracked taillight, that it was just this is a different officer. Sorry. So he talks about the cracked taillight. That's what I wanted to show you. So they capitalize on your choices of words that, you're probably not giving it a little bit. You're not giving it a thought. Here's how Elizabeth Little, and thanks to Zonker, everyone is insane on Twitter for clipping this.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay.
It's because they think cracked is not broken. If you have a cracked screen, don't you, on your iPhone or Android phone or whatever, don't you consider it broken? Don't you go to get it fixed? You're not taking it to get it fixed because it's intact.
The 40.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay. So just keep this in mind. How do I go back? Okay.
The light was not completely damaged. It was cracked and a piece was missing. The light was not completely damaged. It was cracked and a piece was missing. The light was not
Okay, so they're saying, how did 47 pieces come out of this cracked but not completely missing taillight? Here, Hank Brennan explains it. Take a listen.
Missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we turn those over to the defense. And I just wanted Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that please, thank you very much. On that wall, on that garage wall, there's a 4, it is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that salad port. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the salad port. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. And this is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at exhibit 6, please. And this is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the salad board video is relevant to showing rape or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so we can get a clear look of that rear taillight missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone.
Isn't that curious? Because in the early, I wonder if we saw doctored footage from the defense, from the ring light video. Remember how red it looked in the beginning? Or is it just the suggestion now to look in the center and see the white? Maestro, do you remember if it was this red? When we looked at early views of this video, it seemed like the red was much more exaggerated in this area. No? But you can see right on the edge, this goes red all the way around. Here you can see it's white right there. And I know people on this side of the fence were pointing it out, but I just remember the overall effect, and maybe this is just with the, I know what to look for because there's going to be another video shown in a second. Maybe the suggestion of it has changed my view.
As it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's
So this was a big, big talking point of the Free Karen readers early on. It doesn't get talked about as much. Now they don't know how anything happened, just that things were planted and why come everything is so weird. That's basically the assumption. I don't know what they're saying. ARCA, ARCA, ARCA became the refrain. Independent witnesses showed that it was impossible. Now I don't know what they're saying. Generally, I hear that Hank Brennan is corrupt. So they move with the recent filings. And that's what they were arguing in court today, that Hank Brennan is in fact corrupt, not Karen Reed's corrupt, lying lawyers. They're not the ones who are corrupt and lying. It's Hank Brennan and Adam Lally and Laura McLaughlin, who, by the way, again showed her strength, had the documents, had the dates. She must know this case inside and out. She's like a real whiz.
testimony, day 31 of trial. It's noted as Exhibit 10 in our package. Page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert.
Right. So the ARCA witnesses who said it was impossible that John's head wounds were inconsistent with being hit with a vehicle, looking at a tiny fraction of evidence and having tailored their testimony to the defense's wishes, said in court that she couldn't have done it there. And Karen said after court, in one of her media interviews, walking to her car after court, that's how she damaged her taillight, with her love tap. And this is very much like Karen Reed creating her own evidence. She likes to get rid of evidence and add her own. So she added her own. She had to have a story how she did it somehow.
And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight.
Nudging. The
defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that taillight is missing well before that vehicle makes it to the Sally Port area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up to the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective in Denton said, just like the 508 ring video shows, is missing. There's no plant. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are 2 videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Denton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. What are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes its canton. And just like 508 in the driveway of Meadors, John O'Keefe's home, you will see that right taillight, 9 white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash?
I mean, what is this? You know how she always asks the Commonwealth to do this kind of stuff and never the defense?
Flash drive of all of these exhibits?
Oh, there we go.
Okay,
If you look at it on a small screen, see right there?
I do see it.
Yeah, and
Does everybody see it? So it should be red all the way around. And just as Karen Reed describes it, looks like you might be able to see in through to the light bulb.
and then you'll see it again. So the alarm.com video contradicts the defendant. If anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense position that there's any relevance to the Sallyport video, that there's any type of body is from herself. Ms. Reed spoke to the boss on June 20th, 2023. And in that testimony, or in that interview, she said, I was seized, there was a pieces of taillight missing that I had picked out at John's at 6:15 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that light is missing before the car makes it to the foot of the Sallyport, so there can be no plan.
Should we say the quiet part out loud or the loud part out loud? That video is from Karen Reed's parents. It's called something else. He just called it. It's not Ring camera video, but it's called something else. Essentially a Ring camera video. Their security video at Karen Reed's house, where she immediately drove her car to. Got it the heck out of Dodge. Tried to hide it from the police, just like she tried to hide her cell phone. That's normal behavior. Along with never talking to the O'Keefe family again. That's normal behavior, no? Never comforting the children that she was so close with and not resentful for, didn't have resentment towards at all.
That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's
What did you think he meant by that? I understand the temperament of the court. Does he mean the temperament of the court? Does he mean that I understand that you're very prejudicial towards the defense? Or I understood that you're not having any of this jury tampering nonsense because you've already had it out with Jackson. Is that what she meant? Let me know what you think.
important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with.
So I really wanted to play this part because here is Hank Brennan perfectly describing how innocence fraud works. Now, mostly, like I've said before, we see innocence fraud done post-litigation. In this case, it's pre-trial, which makes it much more dangerous. Tampering with the jury pool, and we've already seen, I showed this morning, that there were these flyers sent out. Hold on, 1, 2, I'm not sure if they were sent out or passed out, but it says, smart people know Karen Read is innocent. Smart citizens know Karen Read is innocent. A friendly reminder, and then it goes through the Karen Read Innocence Fraud Campaign talking points, and at the bottom it says, for more info, visit 34fairview.com or Facebook. And there still wasn't a gag order in this case? Nothing was done about this? Did Judge Cannone know about this? So I'm not certain how recent, if it was now or earlier that these were handed out. Just the fact that they were distributed is so disturbing. But listen to Hank Brennan describe how this campaign works. Take some minutia, blow it up, make the heroes look like villains, and make the accused murderer a folk hero.
And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. Then why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence, just saturate the public. Now, it's important to see or hear or read what is said. Because this really...
So just before he reads what was said, saturate the public. So I spoke this morning about the illusionary, or yesterday morning, can't remember which, the illusionary truth effect, that the more something is repeated, the more we believe it is true. So whether it's that vitamin C prevents colds, or that goldfish have 2-second memories, or that gum takes 7 years to digest, we're prone to believe it. So the more that you say corruption in Canton, corrupt police, Karen Reed wrongfully accused, a case so full of holes, a case that should absolutely be acquitted immediately, that any sane, wise person would support Karen Reed, it gets believed. There happens to be no evidence to support those claims about Karen Reed or the Canton police, for that matter. But just keep repeating them over and over. We're watching the corruption. This is the corruption. Lawyers breaking the law flagrantly in court, and a judge just permitting it and almost applauding it, you know? So deferential to this defense team.
The acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fannin. Not a coincidence. And so during this interview that the defendant and the attorney have, the questions asked, I don't know why.
Right. So they're getting ideas from, they have a whole army in the public, including, so I don't know if Aidan Carney thought this up or someone in the Free Karen Reed movement, and Aidan Carney wrote a blog, but there goes the idea, catches fire, that Lieutenant Fanning somehow tampered with the jury. So it's really, it's sometimes called participatory defense. But I mean, it's straight up fraud.
Why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might.
That's my view of it. Let me go back. I'm sorry. Let me just go back a second so you can hear.
View is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fannin. Not a coincidence. And so during this interview that the defendant and the attorney have, the questions asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well in the trial, as a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Joan, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
So he's referring to the interview that they did with Ted Daniel, their big Super Bowl interview that was cut up into a million pieces and released piece by piece. And now there's another interview where they're driving around, or Karen's not driving, she's riding around giving an interview. Someone said it was like that comedian who does the singing in the car, the British comedian.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, the villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning.
Well, I would disagree with that. It can't be anyone. It's usually the people that have the most knowledge of Karen Reed's guilt. So police officers, the family, the witnesses, those tend to be the ones on the chopping block.
Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
Did you guys see that, Karen Reed? Check it out again. Watch Karen Reed on the right-hand side of your screen. Make faces, and this is allowed. Judge Canoni lets this go on. Ready? Look at it. She looks back at her brother or her parents or her mother and makes a face. Ready? Watch.
Most conscientious, dedicated.
Watch Karen Reed. One more time. Keep your eye on the right.
Is one of the most conscientious, dedicated.
You see her? You see her making that look?
Admired.
You guys catch it? And Hank Brennan catches it and stares her down. Ooh.
State police officers in Massachusetts.
Wow, a little eye-to-eye contact between the killer and the prosecutor. Wow.
After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, You look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They tried to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification.
So this is something. So if you miss what was happening there, so Lieutenant Fanning, they said they made an investigation into his corruption because he was on the text message chain where Proctor was writing inappropriate messages. Because he wasn't immediately admonished by Fanning, Proctor, who's working long hours in a nor'easter, that he was investigated for corruption. This is the same thing they did with Amanda Knox, the prosecutor, they would say in her innocence fraud campaign, that the prosecutor in that case was under investigation for corruption. Of course, he was cleared, but they never clear it up when he's cleared. They just hang over the idea that it's the same reason that they got a federal investigation, to make it look like something nefarious went on, make it look like he was up to something bad, just by mentioning that there is an investigation.
Of that through the pleadings. Counsel was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last fall. I can provide the date right now.
There's Laura McLaughlin for the save. Superwoman. Yes, it was. They knew that he had already been cleared, but why say it in the filing? I think this is a good place to leave it for today. That's how it works. That's how you do an innocence fraud campaign, guys. It's a good lesson by Hank Brennan and how to make an innocence fraud campaign. I've been going since 11 o'clock this morning. So I'm going to sign up for tonight. I'll see you tomorrow at 6 p.m. Eastern. Have a great night, everyone. Please share my work. Get the message out about innocence fraud. Leave me a comment. I do read all the comments. I get a lot out of them. Hit the thumbs up on your way out. If you would like to support my work, Patreon link is in the description of this episode. Also, my t-shirts are below. You can Venmo me a donation, or you can buy me a coffee, all in the description of this episode. Have a great night, everyone. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and a witness. system, my clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system, my clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. My John, you were my